In the autumn of 2025, Britain's immigration courts found themselves at the centre of an unexpected controversy. A lawyer representing two asylum seekers had unknowingly included imaginary case law in an appeal material that turned out to be the work of an artificial intelligence program. The episode, which was recorded in a judgment from the Upper Tribunal, Immigration and Asylum Chamber, has since become one of the earliest and clearest examples of what happens when legal professionals depend too heavily on generative AI tools. 1. The story behind the appeal. Two sisters from Honduras had asked the United Kingdom for protection, explaining that they feared violence from the criminal organization MS-13. Their claim was first rejected by the Home Office, and later by a first-tier tribunal. They then turned to the Upper Tribunal, hoping to overturn the earlier ruling. Their legal representative, identified as Mr. Rahman, submitted an appeal document listing a dozen legal decisions that were said to prove errors in the previous judgment. The document looked professional, but several references did not match any known cases. Others were genuine decisions but had nothing to do with the legal issues being discussed. One striking example was a citation for a supposed Court of Appeal case referred to as Y, China, 2010, UK Civ 116. When the presiding judge, Mark Blundell, checked it, no such decision could be found in any recognized UK legal database. 2. What the judge uncovered. Judge Blundell asked the barrister to bring printed versions of all the referenced cases, with the important parts marked. When the hearing resumed, the lawyer could not locate some of the judgments at all, and others clearly failed to support his written claims. In a detailed note attached to his ruling, the judge reasoned that the most plausible explanation was that the lawyer had used text generated by artificial intelligence to draft the appeal. He concluded that the materials were probably produced, at least in part, by a generative AI tool and that the lawyer had not been forthcoming about this when questioned. Although the judge accepted that the problem appeared to result from carelessness rather than intentional deception, he stated that the conduct fell far below the standard expected from members of the legal profession. Because there was no evidence of deliberate dishonesty, the tribunal decided not to involve the police. However, it issued a notice indicating that the matter would be reported to the Bar Standards Board, the organization that regulates barristers in England and Wales. The asylum appeal itself was dismissed. The tribunal found that the original decision was legally sound and that the sisters' accounts were not sufficiently consistent to justify refugee status. 3. Earlier misuse of AI. The same barrister had already faced scrutiny earlier that year in a different immigration matter involving a Bangladeshi client. In that case, the tribunal confirmed that he had used the ChatGPT platform to prepare legal arguments. The program had generated fabricated authorities, including the same non-existent Y, China, case. That earlier decision, published under the title MS, Professional Conduct, AI-generated documents, recorded the lawyer's admission that he had relied on a chatbot for legal research. The tribunal called the behavior unacceptable and formally referred him to the Bar Standards Board for investigation. By the time the Honduran sisters' appeal was heard, Judge Blundell was aware of this background, which informed his conclusion that the second set of faulty citations was also likely created by AI. 4. What this case reveals. The combined findings of these two rulings expose one of the most serious risks of generative AI systems: they can produce content that looks legitimate but is completely false. In technology circles, this is often called an AI hallucination. In ordinary writing it may be harmless, but in legal practice it can mislead a court and undermine justice. The tribunal's reasoning made several key points clear. Verification is mandatory. Legal authorities must always be checked against official sources such as Bailey, Westlaw, or LexisNexis. Technology cannot replace judgment. AI tools might summarize information, but they cannot understand the law or decide what is relevant. Honesty is essential. Failing to confirm AI output or pretending it is original research can breach professional ethics. The judgment also served as a reminder that lawyers are personally responsible for the documents they file. No matter how advanced the software, it is the human professional who must ensure accuracy. 5. A wider pattern. This was not an isolated situation. In the United States, several lawyers have been fined or reprimanded for filing court papers that quoted non-existent judgments created by AI chatbots. In the UK, senior members of the judiciary, including Dame Victoria Sharp, have warned that misuse of such systems could lead to disciplinary action or even criminal liability if false material is knowingly presented to a court. Professional regulators have echoed these concerns. The Bar Standards Board and the Solicitors Regulation Authority have both issued guidance reminding practitioners that technology can help, but never absolves them of their duties to verify and to be truthful. 6. Implications for the profession. The events of 2025 mark a turning point for legal ethics in an age of automation. Artificial intelligence can accelerate research and improve productivity, but it cannot distinguish between truth and invention. Lawyers, students, and researchers must therefore act as critical reviewers of the information these systems produce. Practical safeguards include checking every authority directly in a trusted database, keeping a record of where each citation was verified, avoiding the submission of AI-generated text without manual review, being transparent with the court and clients about the use of such tools. Immigration cases, in particular, deal with vulnerable people whose futures depend on fair and accurate advocacy. Submitting fake or irrelevant authorities, even unintentionally, risks damaging those clients' cases and eroding trust in the legal process. 7. The ongoing significance. The upper tribunal's rulings in 2025 are now widely discussed in professional seminars and training sessions as real-world examples of AI misuse in law. They remind every practitioner that legal responsibility cannot be delegated to software. Judge Blundell's conclusion can be summarized simply: AI can help draft or summarize, but it cannot think or guarantee truth. A lawyer's duty is to check every fact and every citation before submitting them to the court. Any authority relied upon must be genuine, verified, and relevant, never the invention of a computer program. If you found this video helpful, don't forget to like, subscribe, and hit the bell so you don't miss the next one.